Gonna pop in here.
Can you hear me?
I can. Yep.
Okay, perfect.
All right. Good morning. Good morning. Happy Tuesday. Well, we are back again for Tuesdays at 10ish, and it is 10:01. So we are right on time this morning. And I am here today with the lovely attorney Shara Kamal. And we've got some more exciting topics to share with you today. It is September 1st. So, what does that mean? New goals. We're into now the fall ish season. And, this is really a great time for home ownership, a great time to buy. The kiddos are going back to school, as Shara and I were just discussing. Hopefully, you and all of your children are doing well and are ready. So, today, Shara is going to share with us three things that buyers typically don't know about their real estate contract. So, one of the things that I love that you always say, Shara, is that it pays to have great counsel. And when you're looking at a real estate contract, there are so many different line items and so many different things that were probably just to the eye that is not honing in on some of those line items, it can be a little bit overwhelming. And so, of course, there are things like dates and there are purchase prices and there are concessions. But what are some of the things that buyers really don't pay attention to as it is relative to a real estate contract?
Well, one, and thank you for having me again, Cecelia.
Absolutely. Always a pleasure.
You. One of the things that I frequently encounter with clients that are in negotiations with, and if I'm representing the buyer, of course, when they're in negotiations with the seller, they believe that everything that they discussed with the seller, maybe directly or through the agent, is what will end up being on the contract. So if there are terms that, like post closing possession, if that comes up, if there was a conversation about replacing the carpet or doing a deep clean of the carpet or making certain repairs that don't make their way to the actual document, the assumption is that those agreements will still be firm and still be in place. So the first thing that I'll say is, you've got to understand that that contract is the final representation of the agreement. So it's important that every term that was agreed upon be represented in that document, because that is what is going to govern the rules of the deal. Okay, this is what your attorney's looking at, this is what your lender's looking at, this is what the two agents have orchestrated. Hopefully it represents the meeting of the minds between the buyer and the seller. So that document, it's important that all of the terms of the agreement are reflected there on that document. In any addendum that might follow, that agreement needs to be solid and complete.
So I'm going to pause you and I'm going to ask you, what is an addendum?
So an addendum is an agreement after the fact. So you enter into the agreement, you present your offer. There might be some changes that might come up. Sometimes if there are repairs that are to be made, it'll be reflected in an addendum or not a side agreement, but it's an agreement after the initial contract is put in place. If there's a change to the purchase price, if the property doesn't appraise out, we'll have an addendum to the contract to reflect that change in the initial terms of the agreement. If the closing cost credit should happen to change, if it's to be increased or to be reduced, it's reflected in that new representation of the agreement, which is the addendum. Both parties need to sign off on it. The lender needs to have final say so and approval on it. So just because, and this is probably number two, just because the parties have agreed on a thing doesn't mean that the lender will approve that thing. So you want to make sure that the lender's on board, and this typically comes up with respect to repairs. Lenders usually not going to allow for any repairs to be referenced in the agreement that are not completed prior to closing. So if it's in the contract, the lender's going to want to make sure, right, that those repairs are made prior to closing. Closing costs. If the parties decide that $15,000 is what the agreement is going to be with respect to closing cost assistance, the lender needs to be okay with that. I've had so many clients that say, well, we can do this with the money. Well, if your lender says we can do that with the money, if that's how they've approved it to be passed along to you from the seller, then we're good. Otherwise, if it violates RESPA rules and regulations, we cannot do it. It's an agreement that's between you and the seller. It'll have to be worked out outside of closing. But yeah,
And I
it's
was
an
going to say, I'm glad that you say that, you bring up that point, because I've been getting asked a lot. And even though the environment is such that we are in a seller's market, I have been getting the question, how much can the seller give towards closing costs? So for an FHA loan, the seller can give up to 6% of the purchase price for closing cost credit. On a VA loan, the seller can give up to 4% of the purchase price for closing costs. And then on a conventional loan, the seller can give up to 3%. So when we're talking about what the lender will typically approve, those are your numbers. FHA is 6, VA is 4, and conventional is 3. Anything that's going to fall outside of those parameters are going to need to be renegotiated.
and it can be done. It's just a matter of not waiting until the last minute to make those agreements. Probably number three is that your contract is a fluid document, right? While it's set in stone and these are the terms that the parties are looking to have govern the transaction, it is fluid. It's a living document. It can change with an addendum. So it's just a matter of making sure that both parties are on the same page and that the lender is okay with the changes that are made, and then making sure that final representation is in writing, so that at the end of the day, at the closing table, we know what we're monitoring to make sure that all obligations on both sides are met and we can have a complete closing. If there's anything that's outstanding, it's hard to deal with that after closing, unless it's something that's to survive the closing, a post-closing repair agreement, post-closing possession agreement, anything that might follow the closing also needs to be represented in a final contract agreement.
That is wonderful. Well, I know that you are off headed to closings today because that's what we do. ABC, always be closing.
That's right.
And thank you so much for sharing those 3 tips with us. Of course, we'll be back again. But Shara, please tell people how they can get in touch with you.
Sure. You can reach me at sharakamal.com, SHARAKAMAL.com. I'm also on all of the social media channels at Attorney Kamal.
Wonderful. Well, thank you so very much. And of course, you guys know I am Cecelia Marlow, the mortgage mom and vice president with the Federal Savings Bank. If you have lending questions, please feel free to reach out to me directly. And any of your real estate attorney questions or contract questions, please feel free to reach out to Ms. Shara Kamal. Have a wonderful rest of your Tuesday, and I will talk with you soon.
Okay, talk soon.
All
Bye.
right. Thanks. Bye bye.